At this time, I have the honor and pleasure of welcoming the bench of the Supreme Court of Canada to Town Hall.
Presided by Chief Justice Myanmar. All right. Our court is now effective. We are
Council, I think we're ready to go.
Justices, may I find myself along with the court?
Certainly.
May I proceed?
Yes.
Good afternoon, justices of the court. My name is Anthony Cheetah, and my co-counsel's name is Cassandra Harvey. Today, we represent the appellant, His Majesty the King. Before proceeding with our submissions, would the justices like a brief summary of the facts of the case?
We've read your materials, counsel, so you can just go ahead with your argument. Thank you.
Thank you, Justice. Justices, this case is fundamentally about ensuring that young offenders who act with adult level maturity are treated as such. Accordingly, the appellant requests for the Supreme Court of TownHall Cup allow the appeal, set aside the youth sentence imposed by the Supreme Court of Canada, and reinstate the adult sentence. The appellant has 3 submissions to make today. The first 2 will be delivered by myself, with the first being that the proper standard of proof to rebut the presumption of diminished moral blameworthiness is beyond a reasonable doubt. Second, on the facts of this case, the Crown managed to rebut the presumption. Third, and handled by my co-counsel, the Supreme Court did err in setting aside the adult. Turning to my first issue, the only constitutionally correct standard of proof to rebut the presumption of diminished moral blameworthiness is beyond a reasonable doubt. That is because Section 7 of the Charter of the Amendment. Section 7 protects the life, liberty, and security of the person. And the state can only limit those rights if they are in accordance with the principles of fundamental justice. Here, the presumption of the diminished moral blameworthiness. As the Supreme Court held in Pearson, the criminal standard applies under Section 7 if 2 conditions are met. First, the state accuses an individual of moral wrongdoing. And second, the state then seeks to impose serious liberty-depriving consequences in response. This is further affirmed in the case of Gardner, where the Supreme Court confirmed that proving contested aggravating facts at sentencing must be done beyond a reasonable doubt. The same 2 conditions are met in this case.
You're conceding the first issue. Is that correct?
Just, it's not that we are conceding it, it's just that we are addressing that the lower courts did misapply the proper standards, as there's abundant case law that supports beyond a reasonable doubt. And the case law that is supported by the Crown is prior to DB.
So you're agreeing with the Supreme Court, the appropriate standard is it stand beyond reasonable doubt?
Correct. We agree with the majority of the Supreme Court.
Okay.
Yes. So first, rebutting the presumption involves accusing a youth of having adult-level moral wrongdoing, of having adult-like judgment, independence, and maturity during the offense. Second, the consequences are profound. Under the Youth Criminal Justice Act, the maximum sentence for first-degree murder, the charge in this case, is 6 years of custody and 4 years of community supervision. Meanwhile, The same sentence under the criminal code for an adult is life imprisonment. That is the starkest liberty differential in our system. Therefore, it is not the inquiry that informs how the presumption is rebutted, but it is the charter. Satisfaction, as argued in the lower courts, is not a standard of proof at all. As illustrated by section 553, subsection 1 of the criminal code, which deals with labeling an offender as dangerous. That provision also only uses the term satisfaction.
Is there a suggestion here that we're supposed to consider the dangerous offender? I thought we were trying to determine adult versus.
No, Justice, you are. We are just determining adult versus youth, but it is a parallel between the two, as the provision in the criminal code only uses the word satisfied. But the Supreme Court cases of Curry and Boutelier held that satisfied in that context, where the consequences of liberty deprivation are severe, must be read as satisfied beyond a reasonable doubt.
So if you're agreeing that the applicable standard is beyond a reasonable doubt, then Supreme Court is likely to agree. The Senate judge obviously didn't apply that standard. So where do we go from here?
No, Justice. The case of Lacasse makes clear that an appellate court can only intervene with the sentence if there is an error in principle that has a material impact on the sentence. We maintain the position that although he did apply the improper standard of proof, 3 features of the record demonstrate that I am acted with adult level maturity beyond a reasonable doubt. Those being his circumstances, his conduct before and during the offense, and lastly, his conduct after the offense. First, his circumstances. I.M. was nearly 18 years old when the offense occurred. And courts have consistently held in this country that the closer a youth is to adulthood, the easier the presumption is to rebut. Equally important is context. The record shows that I.M. admitted himself to selling drugs and committing burglaries for 5 years to support himself financially.
But counsel, couldn't that also indicate a lack of maturity rather than pointing to the fact that he was sentenced as an adult?
No, Justice. The decision to deliberately provide for himself outside of parental support is itself indicative of a mature life reasoning. Our friends make the point to his background as a source of vulnerability to explain his involvement in crime. However, we would submit against this, as the record clearly shows that I have had a supportive family and a stable.
And that's fair, but wasn't he ultimately recruited into, I guess, some sort of criminal activity here? And he started off, but he was quite impressionable when he was 12 years old.
Justice, the record does say that I.M. was recruited. However, I believe it's important to emphasize that at trial, the defense never put forth evidence, and I.M. never admitted himself to ever being pressured, coerced, or convinced into crime. The record, in fact, supports his own independent judgment in continuing to do so.
Well, does it support his own independent judgment making that choice, or is the record that silence is how he entered into the criminal crime? Because wouldn't silence suggest that there's an ambiguity, against a finding that it's satisfied beyond a reasonable doubt?
Justice, even if his entry into crime is ambiguous, his sustained choice to continue to engage in it must be reflective of independent decision, as there is nothing in the record to contradict that finding. Furthermore, his conduct before and during the offense heavily support rebuttal. The record clearly shows evidence of planning, as the text messages initiated between I.M. and his co-accused show meticulous planning, and it even shows I.M.'s interest in obtaining a firearm beforehand.
These are all facts that all go towards the conviction, not his first degree murder conviction, planning and preparation are elements of that. And as we put it, the gravity of the offense can't actually factor into the rebuttal presumption.
Yes, Justice. The seriousness of the offense goes to the second prong. However, in the British Columbia Court of Appeal case Scholl, the justice in that case outlined a number of factors that are appropriate to consider for the parts of the case that I've outlined, the circumstances, its conduct, and so on. In that case, and regarding before and during the offense, one of the key considerations is evidence of planning and premeditation. And just to the further point of first degree murder, he was convicted of that under the idea that it was unlawful confinement of the murder. we will concede that the murder itself was not planned, but the record still shows significant planning. And this is distinguishable from the case of Okama, for example, where the two youth in that case impulsively went to go commit two armed robberies. And the judge in that case found that that was impulsivity, which is therefore indicative of immaturity.
But is this not also indicative of immaturity? This was planned with other adult offenders. So, I mean, he's the youngest, so is it not possible there was some influence by these other offenders who want to press them? Does that not speak to immaturity?
Justice, while I understand the record does not support that. The trial judge himself found that I.M. was internally motivated. He was never pressured to join the robbery, he was never coerced, and he needed no convincing on behalf of his peers. He independently chose to do this as soon as his co-accused SD informed him that the victim had 4 shotguns that they could target.
Right, but what standard did the trial judge make that finding? Because you can see the appropriate standard for rebutting corruption is beyond reasonable doubt. So did the judge make that finding on that factual standard or during the trial where beyond reasonable doubt?
That was during the trial. It was beyond.
That's a fact beyond reasonable doubt.
Absolutely.
Yes. Thank you.
Furthermore, if we look at his conduct during the offense itself, it also supports rebuttal. Even despite the unplanned murder, and despite the fact that he was severely injured to the point that his pinky was barely holding on to its tendon, he didn't panic, and he didn't flee the scene out of fear of his life, as we would expect of a youth. Rather, he showed composure and the same amount of emotional regulation on par with his adult criminal peers. That is fundamentally inconsistent with the diminished maturity that we see in youths.
Also, don't we balance that against the post-defense conduct where he sent goes to school and essentially outs himself to his peers? Hey, look what I did.
Yes, Justice. We do also submit that after the offense also supports the vote. But to your point about the bragging, we would submit that a singular moment of bravado doesn't outweigh a sustained pattern of deliberate conduct before, during, and after the offense. And as for the conduct after the offense that supports rebuttal, I point to the fact that I.M. himself acted to conceal evidence in a strategic manner and also fled the country shortly after the offense. This is very inconsistent with other cases of youth who displayed vast immaturity in getting rid of evidence.
I struggle with this point as well, counsel. It's like, surely isn't it mentioned that children are incapable of hiding evidence of their malfeasance and attempting to evade the surveillance of their supervisors?
Absolutely, Justice. But the case law is also clear on this point, that acts to conceal evidence in a way that is effective in doing so is in itself indicative of mature-led planning. And I would like to contrast this with the case of BJN, where the accused in that case shot another person with a gun. And in order to get rid of the weapon, he asked his mom to dispose of it. That is something that we would expect a youth to do. We wouldn't expect a youth to take advantage of the fact that he could internationally escape. And it's also important to emphasize he was gone for 3 years.
Who planned that?
It was his family, Justice.
He went on that.
Correct.
All right.
However, the record shows that he ensured his co-accused would commit the robbery before his departure date, as evidence is showed by the text messages that he asked his co-accused to not pull up on him on January 24th.
He ultimately returned 3 years later. He didn't, again, never come back.
Yes, Justice, but the mere act of taking advantage of a chance to internationally escape accountability is indicative of adult-like reasoning. And I'll contrast that with another case of Henderson, where the accused in that case tried to avoid accountability by hiding behind her victim's couch. That's a clear sign of immaturity that is fundamentally not present in this case.
Well, if you don't think that going on a pre-planned for mom and dad is also a sign of immaturity, we're talking about an answer.
It shows foresight, Justice, and foresight is typically attributed to adults.
Foresight, but he didn't plan the trip himself. It was his family.
Although it was his family that planned the trip, Justice, that goes back to the facts of this case that I.M. wasn't the only one who planned the robbery, but the fact that he was involved in that plan in the first place shows adult judgment. And I would extend that to him taking advantage of the family's trip.
What weight do we afford to, again, him, some sum it up as a bravado, him literally taking a bloody trip to school, almost for show and tell?
Justice, we do take it as a sign of immaturity. However, that is up to the sentencing judge to afford weight to. And absent any error in principle that has led to a material impact, it is not for this court's role to reweigh the evidence that was before the sentencing judge.
But it would be relevant to this analysis of 71.
Yes, and it was a part of his analysis, but he found that there was enough evidence to rebut the presumption, which we maintain before this court. Therefore, justices, to put it simply, if one had stripped IM's age away from the record, a reasonable person would conclude that this robbery was conducted by only adults.
Oh, we can't, yeah, we're not allowed to do
You're asking us to consider some factors, but then eliminate the factor that arguably Parliament doesn't identify as the most important factor. Parliament literally creates and retaining people that are the age factor. Okay, sort of, below each person obviously is. So how can we strip away the age of the offender in this analysis?
That's
May I have an indulgence to answer your question? Thank you. Just as the point of saying if one stripped away the age of IM from the record is not me asking this court to do so. But when we are trying to determine the maturity of somebody, the point that is established is that if age was unknown, a reasonable person would conclude this offense only involved adults. It is only by nature of the record, including his age, that we are even here before this court to discuss whether the presumption is rebutted, which we maintain it has been beyond reasonable doubt. Barring any further questions, I will allow my co-counsel to demonstrate that the Supreme Court did err in setting aside these adult sentences. Thank you.
May I time myself along with the court? May I proceed? Good afternoon, Justices. My name is Cassandra Harvey, and I will conclude the submissions on behalf of the appellant, His Majesty the King. My submission will contain two parts. First, I will demonstrate why a youth sentence would not be of sufficient length to hold IM accountable. And second, I will explain why the Supreme Court of Canada did not have the right to intervene with IM's sentence. Turning to section 72(1)(b) of the YCJA, whether a youth sentence would be insufficient to hold a young person accountable. Justices, accountability requires proportionality to the seriousness of the offense and the degree of responsibility. This offense is one of the most serious imaginable. The victim, ST, was only 17 at the time of his brutal murder. The co-accused and IM terrorized his family, and they struck his mother on the head with a gun. They forced her head between her legs, and they forced her to listen while her son was murdered. The family has had devastating and lasting harm. The mother continues to suffer from both emotional and the physical toll of losing her son.
We're talking again about the seriousness of the offense. I'm wondering the lead up to what we're supposed to be considering with respect to sentencing under the criminal justice. What does it direct us to do with that?
We are supposed to consider the harm that it had on the family, the protection of the public, and the rehabilitation and reintegration of IM back into the community.
So how does the proposed sentence, from your perspective, meet those criteria? I understand the talking about offense, but how does it propose or to integration?
Sorry, I couldn't hear the last part.
So how are you proposing that if we're looking at the principles that the government is directing us to apply, how are we going to meet the principles of rehabilitation and reintegration in this case?
Justice, it is the appellate submission that we would only meet those principles if IM had been given an adult sentence. And I'll direct the court to Dr. Pierce's report where he notes that IM has a lack of remorse, he had a lack of empathy, and he didn't see many of the rehabilitative programs being beneficial to IM because of his antisocial conduct disorder.
Council, are you suggesting that an adult sentence would better meet principles of rehabilitation or?
Justice, we are submitting that an adult sentence would address the seriousness of the offense, taking into account what had happened with IM, the circumstances of the case.
So that's all in the equation. You also have to look at the moral worthiness of the offense.
Correct, Justice.
So why do you think that a long jail sentence would better meet those sentences?
Justice, I'll turn the court's attention to the Queen and the Clements. Paragraph 48, it's 2017 NBCA 104. Pardon? Yes, Justice. And so at paragraph 48, the justice notes that a youth sentence must satisfy two objectives. It must be long enough to reflect the seriousness of the offense, and it must be long enough to provide a reasonable assurance of the young person's rehabilitation to the point where he or she can be safely reintegrated back into society. And it is the appellate's submission that IM would only be able to effectively potentially be rehabilitated and reintegrated with an adult sentence based on the circumstances and the seriousness of the offense.
You're asking for a life, are you not?
Yes, Justice.
So how does being reintegrated back in society factor into your proposition for a life sentence?
Justice, this case was sent back to the lower court to determine, again, his eligibility for parole, so he would be eligible for parole in 10 years. And to your point, a longer incarceration sentence would justify based on the seriousness of the offense. And IM had repeatedly, while in custody, in pretrial custody, he had 15 misconduct reports. There are very few signs of rehabilitation in this case based on his pre-custody misconduct reports and the circumstances of the offense.
But doesn't the fact that he had his misconduct, go back to your current submission, doesn't that make you indicate a lesser burden level?
No, Justice, because when we look at the totality of the circumstances and the fact that he has been participating in crime since he was 12 years old, he was given bail. And I might mention that during this offense, he was on probation orders. He's been given bail numerous times, has not rehabilitated himself, and he clearly does not show a willingness to participate in rehabilitation.
I want to ask you about Dr. Pierce's report. This is really where this concern about his rehabilitation prospects come from. Dr. Pierce identified the offender in this as having antisocial disorders or antisocial conduct disorder, I think is what it was. If he's suffering from conduct or diagnosable conduct disorder that has a significant bearing on his prospects, would that not, in fact, weigh against you in the sense that it could actually be an indication of reduced moral blameworthiness?
No, Justice. And with respect to Dr. Pierce's report, it was inconclusive. He could not determine whether or not IM did have a diminished moral blameworthiness. He could only speak to his rehabilitation potential and his diagnosis of mental health issues, including the antisocial.
Yeah, like I put to the quality, that ambiguity weighs in favor of a finding that it's been presumptive and rebutted.
No, Justice, because we still have to look at the totality of the circumstances and his pre-offense behavior as well. And I'll point your attention to the case of Okamo as well, where at paragraph 93, the justice also cites that, again, crime rehabilitation and reintegration are, of course, formal and essential qualities of the YCJA, but again, this cannot outweigh the protection of the public. The court.
How does a sentence of 6 years in custody for a youth plus 4 years of supervision, how's that not a fit sentence to being the least restrictive on the youth, most likely to rehabilitate him and to promote a sense of responsibility, considering his previous sentences?
Justice, it's the appellant's submission that he does not have a high rehabilitation prospect, and by giving him a youth sentence.
Why is that?
based on his Dr. Pierce's report with the antisocial conduct disorder, the fact that he has been in and out of custody since he was 12 or 13 years old. It's a finding of fact that he was a principal offender in the murder of ST. He consistently and texted his co-accused adults who he was looking for a gun. He was persistent on obtaining a gun. After he brutally murdered ST, he went back into the house to continue robbing the house and looking for guns despite none being there.
As a young offender, though, shouldn't we be hopefully 17 that there are some rehabilitative prospects? I mean, you have an opinion that isn't definitive and saying that all aspects of rehabilitation are nil.
I take your point, Justice, and to that again, I'll point you to the case of Okamo, where yes, he could potentially, if he was incarcerated in the YCGA, have opportunities to him. But again, all of these opportunities are rendered not useful if the IM is not willing to engage in those rehabilitative programs.
But does he have a better chance of like Weymouth Mercury versus going to a federal institution for life, or at the very least for a minimum of 10 years? Youth institutions have the tools and the resources necessary in order to assist youthful offenders who've strayed away.
Justice, they do have the tools to do that. However, again, it is up to the young offender to actually want to engage in that material. And the mere fact that, again, he has been a principal in all of these crimes that he has committed, and despite being let out on bail numerous times, he is aware of the consequences and what happens when you engage in criminal activity, yet he continued to choose to do so in the circumstances of this case. And therefore, that does warrant an adult sentence based on the seriousness of the offense and the effect to ST's family and for protection of the public. I will now turn to the second part of my submission, that the Supreme Court of Canada did not meet the high threshold for appellant intervention. And I'll turn the court's attention to the case of Lacasse. Intervention for a sentence is only if the trial judge has made an error in principle and if that had a material impact on the sentence. It is the appellant's position that although we do recognize the trial judge made an error in principle when he considered the seriousness of the offense under prong A, that is the appellant's mission. It did not have an effect on the a material impact on the sentence.
Well, I find that difficult to accept, considering that most of your convictions have been about serious offense. So it seems that that's what the focus has been, is just on the seriousness of the offense, and we're forgetting about the other principles of sentencing. It sounds like you've been asking us to propose a sentence of a retributive nature, rather than one that encompasses many of the other principles of sentencing, not the rehabilitation and things like that.
No, Justice, we're asking the court to consider the seriousness of the offense under Section B, or under Section 72B of the YCGA and the circumstances of the offender under Section A of Section 72. And by setting aside the adult sentence, the Supreme Court of Canada had blurred the lines between review and substitution and ultimately undermined trial level discretion that we do owe deference to. And even if the court could differ on how maturity should be assessed, it is not a basis to overturn the trial judge in this case based on the seriousness of the offense. And I reiterate the fact that this was a brutal murder. A 17-year-old was killed by a group of people, and ST had absolutely no chance of resisting or defending himself. And the evidence shows on the record that ST was restrained and was stabbed repeatedly. He had a 12-centimeter stab wound in his face, and that is how he lost his life, while IM was participating in a robbery and has shown a commitment to engaging in criminal activity.
So we're aware of how horrendous this was, and I appreciate your statement. It's helpful to bear this in mind. But when we're assessing whether intervention is necessary, we need some clarity about what ultimately the courts consider and find that they're satisfied with the sentence appropriate. And so I appreciate these facts here, like, help us, but help us with that component. Like, surely you can discuss this now, but how many facts, as far as I understand, were hopefully not evaluated, but were considered in the satisfaction. In the satisfaction sentence. Am I right about that?
I see my time is almost elapsed. Can I have a minute to answer your question and conclude? So if I understand your question correctly, you were asking where the Supreme Court of Canada or the trial judge had erred in their determination of giving a youth sentence.
You're agreeing with the Supreme Court beyond reasonable doubt standard should have been applied, but did not apply for the purposes of the Section 72 analysis.
Correct.
Right. And so, is that not particularly fatal on the factual analysis that the trial judge did in determining whether the moral blameworthiness presumption has been provided?
No, Justice, because even with the beyond reasonable doubt standard, the Crown submits that we have met the presumption of diminished moral blameworthiness.
It could have been the facts the trial judge was satisfied with the Section 72 proceeding. Do we know what standard by which the facts were accepted?
He used that as a standard of satisfaction, and he could use seriousness under Section 72A instead of Section 72B. Barring any further questions, this concludes the submissions on behalf of the appellant.
May I proceed? Good afternoon, Chief Justice and Honorable Justice of the Court. My name is Nolan Calderwood, and alongside my colleague Michaela Mifsud, we represent the respondent, I am. Justices, we are here before you today to clarify the way in which an adult sentence can be imposed on a youth offender. In doing so, we aim to ensure that charter protection given to youth is at least on par with their adult counterparts. And second, clarify the proper treatment of relevant factors to ensure youth benefit from consistency in the application of the law. Our analysis on this matter will proceed in 3 parts. First, the Crown is required to rebut the presumption of reduced moral blameworthiness on a standard of proof beyond a reasonable doubt. Second, the IM benefits from diminished moral blameworthiness. And third, the court below did not err in setting aside his adult sentence. I will address it first, and my colleague the latter two.
And I think your friend repeated the first point that it should be evaluated on a standard beyond doubt. I'm wondering if what you would make of their emphasis on the seriousness of offense.
So, Justices, I'll answer your question in 2 parts. First, the seriousness of the offense is only relevant under branch B of Section 72(1)(a). And regarding conceding the submission on proof beyond a reasonable doubt, we would like to address it nevertheless. Justices, as an appellate court, we're to set a binding precedent that will be carried out throughout Canada. We want to ensure that you arrive on the determination of proof beyond a reasonable doubt on correct grounds. Justice, we say to do so to prevent a future ruling of a current incurable decision, and we say our friend has arrived at the decision in an improper way, and thus it is susceptible to a charter challenge, this decision to charter challenge in the future. First, we accept that our friends represent the Crown. However, in prior iterations, for example, the Attorney General of Alberta disagreed with their conclusion. And second, our friends advanced this as saying it was required by the Constitution, namely Section 7. Up until this point, this issue was never litigated as a charter challenge. This is specified in paragraph 82 at the Supreme Court of Canada. The statute was never directly challenged. We say this is relevant for two reasons. First, the Supreme Court Rules Act, sections 33 and 34, require upon a constitutional challenge that notice be given to all attorney generals. We say in absence of this being brought forth prior, we have rid of the attorney generals in their respective provinces from the benefit of considering and voicing their opinion on the issue.
So are you suggesting that failure to provide notice to all attorney general that we are barred from considering certain issues?
Just so to say, not necessarily barred, but we would say that if the decision is arrived at an unstable basis or without the proper record before us, it would be susceptible to a charter challenge in the future in your decision. And we'd say a ruling of pure and curia and requiring it to re-go for Parliament to re-legislate the issue would delay the protection for youth offenders. So thus we will be advancing.
Sorry, so would you like us to find what the appropriate standard is beyond reasonable doubt? Or not?
Yes, Justice.
Okay. I understand that the appellants have conceded that it is the appropriate standard. If you're not taking issue that we have the jurisdiction to make that finding in circumstances, are you?
No.
Okay. So let's say we make that finding. So if that's the case, then where do we go with respect to your finding?
Justice, we turn to the first and second branches of section 72(1)(a). And the first, it's our position that it was not rebutted on a standard of proof beyond a reasonable doubt. That will be addressed by my colleague.
I think you want to do this right now.
Yes, Justice.
I'll ask you this. I have one issue with this beyond reasonable doubt standard question.
Yes.
It appears as though Parliament rejected the opportunity to legislate beyond a reasonable doubt standard into the legislation. Right? This is something that was expressly considered and ultimately not implemented in the legislation of most recently done the most recent amendments of the Criminal Justice Act. What, if anything, we make of that when Parliament's intention, and how, if at all, should that give us pause with respect to imposing that standard now as a point?
Justice, I would say it gives little effect to the fact that the prior iteration of the bill did include the standard and it was removed. This point was brought forward by Justices Rowe and Cote in dissent. But on 16 occasions, the Human Rights Committee of the House of Commons met to study the bill, and that the standard proof beyond a reasonable doubt was left out of it after the dissolution of Parliament. On this matter, I would adopt the comments of Honourable Irwin Poulter that relying on a prior iteration of Parliament that did not enact a statute is contrary to both parliamentary and democratic process. Justice, further proving the ambiguity that is present in the standard of satisfaction, there was concerns within this iteration of Parliament that this was one of 9 act statutes being discussed in this omnibus bill pushed forth to be made in the first 100 days of Parliament. We thus say that the standard left was an ambiguous one. And as this was a question for statutory interpretation, we need to seek to arrive at the conclusion on stable grounds, provide the court with a binding and stable authority in their decision. We would
explain why you say it's ambiguous when there is a clear standard that's articulated, just not the one that you want. It's not ambiguous.
Justice, I would say ambiguity arises through the text, context, and purpose. So turning to the context, the reenactment of the legislation was brought about in response to the court's decision by DB, and this adopted the very language of Justice Abel in her decision, that youth are entitled to a presumption of diminished moral blameworthiness and culpability. However, she further clarified that the presumption arises through heightened vulnerability, lesser maturity, and a reduced capacity for moral judgment. We say that these factors are factual in nature and attract a standard of proof beyond a reasonable doubt. And this is consistent with prior interpretations of the term satisfaction. I have 4 cases, and in all of them, satisfaction in the standard imposed later is determined by the nature of the inquiry. For example, in the Crown and Curry in 1997, it dealt with similarly a factual question of whether an offender was likely to reoffend. The court had read it to determine that the statute meant a standard of proof beyond a reasonable doubt. Contrary in other interpretations, like fines, they've read in a standard of probability, and with custodial sentences, a standard of satisfaction. We say this couples with the statements in Parliament that this issue be left with courts. And in doing so, as ambiguity arises, I would turn to the two external principles for interpretation. The first being the strict construction of penal statutes. First, we presume that Parliament constructs acts in a way that are unambiguous and clear. And if true ambiguity does arise, it must be drafted in favor of the accused. On this basis, in determining—
Counsel, couldn't we just then take into account that they perfectly left out beyond a reasonable doubt, and it would satisfy, then we're to take it that they can satisfying on down probabilities.
But it's something other than beyond.
Yes, so if the ambiguity arises, it must be drafted in most, actually perhaps I'll turn to the second factor for statutory interpretation. That's the charter values principle. It presumes that the law aims to meet the principles that animate the charter. And we say—
What charter values brings about? What charter values do you believe are like?
Justice, I'd say primarily the presumption of fundamental justice that youth are to benefit from a distinct legal system based on their diminished moral blameworthiness and culpability. And we say that it is a standard of proof beyond a reasonable doubt that best meets this.
Sorry, I have a question about the Assembly judge's findings in this case. Obviously, there were findings of fact about IM's previous criminal record, his involvement in planning to live with deliberation, that kind of stuff. All of those facts were found beyond a reasonable doubt, right?
Yes.
So it's not. So why is it that the standard we're applying to moral blameworthiness, why does that also that when all of the aggravating facts have been?
Just I would say appropriately would be to equate this inquiry to both the question of law and fact. So we do have the underlying factual factors. It's our position we also must arrive at the correct conclusion. Ensuring that the trial judge uses the correct tests and applies the principles in the correct way affords the best protection to youth offenders. And we see—
But if the trial judge does his or her job properly and only finds aggravating facts beyond a reasonable doubt, isn't that sufficient for you?
Justice, I would say it's not, because finding of facts can be construed in two manners, and this affords insufficient latitude to trial judges. For example, courts, such as the one in JFR, have taken these same factors, saying impulsivity or bravado, with one judge saying it is youth-like and one saying it's adult-like. By ensuring that the ultimate standard is also proof beyond a reasonable doubt, it ensures the correct conclusion is arrived at. We'd say under this current construction, this contributes to the issue that has led to an 87% success rate upon application under Section 72(1)(a). That is to say, post-DB, in 109, in the instances post-DB upon application, the Crown was successfully granted a Section 72 application. We say that this is grossly disproportionate, especially in the light of the court's decision in AC v. Manitoba. Although that was a question of capacity and medical decision-making, we say that the principles are nevertheless relevant. They held that although a lower standard could arise when it is beneficial decisions on youth, such as a therapeutic abortion, when the standard was to be used to assess something that would have negative consequences to youth, say preventing life-saving treatment, they held that the standard was so incredibly high. In fact, it had never been met in this jurisdiction. We say similarly, when using the youth's diminished moral blameworthiness and assessing their adult-like behavior, that a high standard be imposed to ensure that youth are not unduly subject to increased penalties. Just, I'd say second in favoring under the charter values presumption is the fact that a standard of proof beyond a reasonable doubt removes improper protection on appeal provided by a standard of satisfaction. This would create a deferential approach to review, allowing intervention only for errors of law or in principle. This provides significant latitude in trial judges' interpretation and decision of factors. This brings forth further Section 7 issues of vagueness. Youth currently are unable to benefit from a consistent application of the law.
Well, counsel, why are you striving for a very consistent application when sentencing is an inherently personalized process? Don't we expect as process of sentencing that people will all have maybe varying sentences, right? How do you reconcile that?
So Justice would say you are correct that there's significant latitude in sentencing decisions, and you'd say this is more relevant under Branch B. However, as I've put to the court, Branch A is more of a factual decision, not asking about sentencing questions, but rather diminished moral blameworthiness, capacity for moral judgment, and so on. We say that these would best be respected and evaluated on a factual basis, and that limiting any undue latitude to trial judges would ensure that youth offenders can advance the best possible defense.
But if Parliament wanted to limit the latter, they could have done so simply by holding specific without standards. It seems to me they chose not to do that.
Just so today, you're correct, they did not specify a standard proof beyond a reasonable doubt. However, in the context of how satisfaction has been used by Parliament to create standards that can be interpreted by the courts, and the Parliament's statement that they wish it to leave it for the courts to decide, we would say that this is the task before us, and I would put to this court to accept a standard proof beyond a reasonable doubt.
So for the takeaway that the Parliament's intent to not put in proof beyond a reasonable doubt, but they just provide to us.
Yeah. There seems to be indulgence to answer your question. Sorry, do you mind rephrasing the question?
Parliament purposely left out proof beyond a reasonable doubt. You were saying that it's just left up to us, then say, well, they really meant proof beyond a reasonable doubt.
Yes, Justice, let's say the principles of statutory interpretation, that being the strict construction of penal statutes and the Charter Values presumption, would tend to a standard proof beyond a reasonable doubt. Barring any further questions, I will leave the balance to my colleague.
May I proceed? Good afternoon, Justices of the Supreme Court Town Hall Cup. My name is Michaela Nixon, and I'll be conducting the final submissions on behalf of the respondent in the case of Bob. I have two submissions to conclude with today. First, we submit that the Crown failed to establish beyond a reasonable doubt that I possessed the mature moral judgment equivalent to that of an adult at the time of the offense. For our final submission, it is our position the Supreme Court of Canada did not err in setting aside IM's adult sentence and imposing a youth sentence. I will address each of these considerations in turn and with respect to the two-pronged test as outlined in the Youth Criminal Justice Act and court below. Justices, age truly is a crucial factor in this analysis. In fact, it is a principle of fundamental justice that young people have a presumed diminished moral blameworthiness because of their heightened vulnerability, lower levels of maturity, and reduced capacity for moral judgment, as my colleague stated. And this is evidenced by particular indica that is present within a factual matrix, and it is our submission that such indica are present in the case of Barr.
But that's the whole reason why people does this. And right now we're trying to grapple with what standard to use for an exception or to do.
Justice, it is our position that it should be a standard of beyond a reasonable doubt, as my colleague submitted on. What the respondent is addressing now is the Section 72 test itself and its application to our client. And the respondent will address a few of the points brought up by my friends, the appellants, and our position on each of these relevant factors. In our view, circumstances of the offense are only relevant to the first prong insofar as they offer insight into the young person's maturity as outlined in the court below. Indeed, in certain actions in a crime taken on its face can emulate these adult-like features.
So what insights typically have into your client's maturity that would help us with this assessment?
Well, Justice will look to the circumstances of the offense, the circumstances of the offender, and the post-offense conduct. Turning back to the circumstances of the offense, we'll take, for example, first-degree murder. This is something that requires planning as an element of the offense, as we mentioned earlier. And this is itself indica of higher maturity. The issue arises here when we improperly emphasize such factors that are characteristics of the crime. This essentially returns us to this near automatic heightened blameworthiness. Is the very issue that DP sought to get rid of, in that case from an over reliance on the seriousness of the offense in the analysis. Rather, it is our submission that courts should ground their analysis in factors isolated from the offense itself, if a youth acted to determine if a youth acted in a particular way because of their usefulness or because of their youthfulness.
So are we to consider the circumstances of the offense or not?
We are to consider it justice. However, it is our submission that the emphasis should be placed on the circumstances of the offender themselves. This is what we would submit, gives us the best insight into the maturity of the offender at the time of the offense.
I understood your outline. You want to discuss the circumstances of the offense, circumstances of the offender, and the post-offense conduct. Did I have that right?
That is correct. And it is our submission that we should ground the analysis in the circumstances of the offender, though we can look to the circumstances of the offense. And we'll turn to that now. With respect to our friend's submission on IM's role in the offense, in certain circumstances, an offense, though violent or serious, such as in the case of Barr, this can actually be evidence of a lack of adult life maturity. Though on its face, it may appear otherwise, it could actually be indicative of bravado, impulsiveness, a desire to impress their peers for the crown and AM. This itself is indicative of reduced maturity. In this case,
something I think that you have to cite cut both ways, both in one way demonstrate immaturity, in another way demonstrate maturity. What, if any, way would you give to a submission that expert evidence is required in order to make sense of whether each way the UCF cuts?
Justice, that is correct, and that is why the respondent is urging this court to emphasize the personal factors of the respondent. To address the second portion of your question, could you repeat the question, sorry?
Yes. What, if any, weight or significance would you give to submission that expert evidence is required in order to determine whether something that a person has done, some aspect of their character, some aspect of their commission of the offense, to understand whether or not that is a sign of maturity or immaturity? Should we be relying on expert evidence or should we not?
Justice, it is our position in accordance with the court below that this is incredibly helpful and in fact it is vital. However, it is not a requirement.
Vital, but not a requirement.
Yes.
Can you help me understand how those are different?
It is our submission that it is not a requirement for a court to make a particular finding based on expert evidence. We agree with the court below on that point. However, we would submit that where such evidence is available, it is crucial to the analysis if put forth. And we'll turn to our friend's submission on IM's role in the offense. In this case, the offense was committed alongside 3 adults, as we've mentioned, and IM told over text message that this offense would be, quote, his come up, as my friends have noted, and we submit this is indicative of a desire to impress his peers by advancing his criminal career. The trial judge made a very similar observation, contrary to my friend's submission, and he notes that IM was motivated by adult peer influence. This is a finding of fact, justices, and we owe deference to it in our analysis. And we would submit that this lends itself to a finding of diminished maturity. As well, Dr. Pierce, as my friends have cited, an expert witness in this case, testified that this offense illustrated a lack of impulse control on the part of IM. This is, again, a clear indication of presumed lesser maturity, as outlined in cases such as AM.
But again, many adults have worked. So,
Especially adults with personalities.
yeah. So, I mean, again, the evidence is going to go ways. So, I'm just wondering what you would have us make of the fact that you're relying on the same thing as your friends, but from a different conclusion.
Well, Justice.
Think of it this way. If I've got a 22-year-old that does all of the same things as your client, that has the same diagnosis for antisocial conduct disorder as your client, we wouldn't even be having this decision, but that would simultaneously having this discussion, but simultaneously, it would be no less plausible. Understand a 22-year-old is quite as capable of everything that your client has done here as somebody who's 17 and 5 months, 5 months old. So does that not sort of weigh against your client's interest here, that this conduct is very much in line with something you might expect from a young adult that suffers from anything your client does?
Justice, it is true, as both of you noted, that older offenders, say 22 years old, can exhibit things like impulsiveness or bravado that we would submit that our client did. But what the analysis is asking us to do is to take all of this into consideration, as well as the background of the offender, which I'll turn to as it seems quite relevant, and determine if they acted in a particular way, either because of their character or because of their youthfulness. And we would submit that the evidence taken together and holistically would lend to a finding of diminished maturity. And we'll turn to the circumstances of the offender, which we have submitted is a very crucial category.
Or just before we leave that, what do you make of the fact that I am, in terms of this role in the incident, was the stabber, was involved in some of the planning? What are we to do with that in this house?
Well, Justice, it's noted by the majority in the court below that an error is made when the circumstances of the offense are abstracted from the young person's maturity and then used to rebut possession. So we'll use your example of deliberate planning. So when abstracted, this can appear to be indica of a sophistication or maturity, this is stated in Troll, but in Justice for Youth and Children, an intervener in this case, they noted that these young offenders, while still immature, can still engage in planning. In fact, they noted it doesn't signify exceptional maturity in the context of criminal behavior. And thus, the mere identification of planning we would submit is not sufficient to reveal the maturity of the offender. Rather, courts must turn to a consideration of these factors to make such a determination.
We're not looking for exceptional maturity. We're looking for maturity that he is, in fact, functioning at least the level that's 7 months older than the chronological age.
Justice, the intervener, when they note it doesn't signify exceptional maturity, within the context of a youth's maturity, it doesn't signify exceptional maturity that would be equivalent to that of an adult. And we'll turn to the circumstances of the offender. Experts have a consensus that youths who have experienced traumatic events, for example, such as poverty, community violence, or the death of a loved one, tend to be worse decision makers and self-regulators than their peers. Indeed, the respondent around 16 to 17 was the victim of a school shooting in that same year. His friend of 4 years was murdered. He also grew up in a poverty-stricken neighborhood and was the victim of near daily bullying by older peers. And so thus the respondent has been victim of multiple traumatic events. And this is also evidenced by the fact that he was recruited to do drug trafficking, as my friends have alluded to. It's also it's noted in
about the issue of recruitment, okay? So we're seeing a serious issue, especially in the GTA. In fact, we've been using comments wide with respect to projections. It tends to be the youth. It's young offenders, right? But it's because they're being recruited. They're being recruited because there's going to be lighter sentences for persons. So are we really incentivizing crimes being committed for young persons and for them to receive lighter sentences when it's in fact these adults who are in the background directing them to commit these crimes? So if we were to take your position today, effectively, we're giving the gold stamp to allow these crimes to continue to happen.
Justice, to that point, the respondent would note that, importantly, there are adults behind the recruitment of these young offenders. And because of their involvement in this doesn't preclude young offenders then from being entitled to what is a principle of fundamental justice, this presumed diminished moral blameworthiness. And we would submit that those offenders should be prosecuted for their role in the recruitment. But turning to the role of recruitment in the case of Barr, it's noted again in Justice for Children and Youth's FACTA in paragraph 33 that resorts to antisocial responses like gang affiliation can be a refuge-seeking response for social dislocation, physical protection, or emotional or financial support. Exhibiting such an affiliation does not necessitate a sort of adult-like maturity and should not be used as a proxy to establish such. And further to that point, the intervener also notes things like street smarts is not always indicative of advanced judgment. And as well, indeed, as my friends have mentioned, Dr. Pierce did find that I am had a lack of remorse, among other things, But this truly misses the bigger picture. As you have noted, Dr. Pierce diagnosed him with adolescent onset conduct disorder and with a risk of developing antisocial personality disorder. And he also, Dr. Pierce testified, excuse me. And we know that cognitive or emotional limitations, such as mental health issues or disorders, are indica of greater vulnerability and reduced capacity for moral judgment, as a young person may not be able to fully appreciate the consequences of their actions. In this case, Dr. Pierce testified in his expert opinion that I did suffer from also a learning disability among the antisocial personality traits. And this would have qualified him for intensive rehabilitation and community supervision. This is something that is only available to an accused who suffers from mental illness or disorder. He also observed that I had poor emotional regulation and had not fully developed moral judgment. He also found the respondent's delinquency, supervision failures, and low school achievement reflected social susceptibility, which goes into the recruitment that we were speaking of earlier, external instability, and limited cognitive development. We submit that this overwhelmingly lends to a finding that IM was vulnerable, and that in turn it lends itself to a finding of diminished moral blameworthiness.
But if it was so overwhelming, if the evidence of its reduced moral blameworthiness was so overwhelming, why ultimately was Dr. Pierce unwilling to state that? In fact, Dr. Pierce was expressly on that very issue. So I appreciate that there's lots of those factors to be considered, but clearly other things are weighing on the doctor's mind when he declines to make the finding you've just submitted to Salons.
May I have an indulgence? Could you clarify your question, please?
Yes, the factors that you're outlining to say overwhelmingly support a finding that your client reduced moral blameworthiness. These are all factors outlined in the doctor's report, correct?
Correct.
The doctor does not, in fact, come to that conclusion, though, does it?
That is correct. So it is.
Help me with that.
It is our position that it is this court's job to come to the determination based on this expert evidence of whether there is a diminished maturity and moral blameworthiness. And it is our position that we have rebutted that. Thank you.
Council will deliberate.
All right. Invite the justices to deliberate. Room. Remain standing. So, again, congratulations to our finalists. That was an excellent showing of oral advocacy preparation, in-depth legal analysis, and I'm very happy and proud of all of you for the contributions you made to our competition, but to your own careers. Because again, this is the steps forward towards what you will become one day, which is great legal advocates. One of the things that we want to do in order to help bolster the striving towards this is acknowledge those who have great legal analysis today. This does not just encompass the finals, but the entirety of today's competition. And so we can announce at this time. We'll do a top three. We'll do a top three.
All right. So tied for third, we had two of our finalists, Nolan and Anthony.
Okay.
There, she got to you, man. Congratulations. So you? Yeah, thanks.
All right. Yes, thank you very much. I think it was all right, over there and over there. Thank you. Thanks, guys. Congratulations.
Yeah,
again.
thank you.
Good job.
And then second place, Cassandra.
Yeah, right. Over there. Ready?
Yeah.
All right. And now we can announce first place best legal analysis today was
Hallam.
Thanks very much. Good job. Congratulations. Do one in the middle first. All right.
Yay!
Nice lady with a perfect. Thank you. Thank you. So The way we're gonna do this now is we're gonna invite our justices back in who are ready. They're ready now to provide theirs. Yep. And they're going to do it, they're gonna announce it. So they're gonna, just like her true decision, the Chief Justice will give her analysis of the arguments and provide us with the decision. Okay, so I will call them back in.
And while Justin is bringing them back in, I guess I'll use this opportunity to thank all of the people that helped put this on. Thanks to our hosts here at Trials College. Thanks to our sponsors, P1 Law, Justice in Pieces, and Elaine Page and the Prep Network. Thanks to all of our volunteers that are here. Thanks. And thanks to all of the competitors for taking the time on the weekend. There's a big Blue Jays game going on as well with the fans and joining us. And we appreciate all of your strong advocacy. And I believe.
All rise.
All rise. Anybody seated?
Council, we want to thank everybody for your incredibly helpful submissions. We have been able to manage the decision. We will be allowing the appeal with the reasons to follow.
Sorry.
Congratulations. The appellant has won. Get a big round of applause.
Well deserved.
Get a big round of applause for our justices. Yes, please come and get a stand up. No, reasons to follow.
Oh, you get the medals and the we didn't define.
You guys will get medal.
Are you gonna hold it?
We can both hold it, like, yeah, together. That's kind of heavy, but.
You go on the other side of them.
Yeah.
There you go.
JP doesn't want to let go of the trophy.
Perfect, thank you very much. All right, so the champions will get, of course, these very nice, I don't know how you characterize those, glass trophies.
Oh, no, touch it out. Stuff it.
Yeah, I don't want no fingerprints on it, so you'll grab that when you're ready. We have the cases for you. The second place to no one is gets these very nice medals. Here you go. Thank you all.